Good morning. Will the clerk please call the first case?
Yes. The first case is being presented under Rule 20, Selwyn Vanderpool and others versus Corporal Hunt and others, docket number 170436.
Good morning, Chief Justice Walker and Justices. It's a pleasure to be here today, and it's a pleasure for me to appear before this newly constituted court. And it's my belief and prayer that this court will serve the citizens of West Virginia well, and I know you will. So we really appreciate your service.
Thank you.
I represent Joseph Boswell, who is with me today, et al. Some of his LLCs were included in the complaint, and the estates of Mr. and Mrs. Vanderpool, or both those individuals are deceased. I'd like to share a little history about the case. Early on, Mr. Boswell and Mr. Vanderpool came to me and wanted to get some advice that Mr. Vanderpool and Mrs. Vanderpool wanted to leave all their property and belongings since they did not have any children, were older, and Mr. Boswell and Mrs. the Vanderpools have developed a close relationship over a period of 8 years, and unfortunately they did some things before time that caused the state or some individuals to believe they were trying to do something illegal, and Mr. Boswell was taking advantage of Mr. Vanderpool. And when they came to me, I indicated to them that they couldn't do it the way in which they were doing it, and they needed to reconstitute that, and we developed a trust. And in that trust, we transferred the properties attempted to transfer the properties to the trust, which Mr. Vanderpool and Mrs. Vanderpool were the trustees. With that said, there was an investigation by the Greenbrier County Sheriff and the State Police regarding Mr. Boswell and their relationship, and a complaint was filed, and some activity occurred. That complaint was dismissed in August of the same year by the prosecutor, Mr. Vi, and as a result of that complaint, we're here today over some of the activities that occurred with how records of their funds were obtained. And that's about the core of the background of the case that I want to share. And what had occurred, there's some questions about financial transactions, and working with the DHHR, Deputy Hunt went to the court to get a subpoena for records. Now, having practiced in Greenbrier County since 1990, the procedure, normally the records were for any activity such as drugs or items of personal property of the house or a vehicle. The issue about bank accounts, unfortunately, was being treated in the subpoena area by the courts and by law enforcement as the same, and the same procedure. And I don't think, because, and I think the court recognizes that I think this is a case of first impression under 31A-2A-1 et Sig, and it's modeled after a U.S. code, the Maxwell Government Access to Financial Records Act, which is a federal act found at 12 U.S. Code 30407, which is a procedure there for judicial subpoenas. And I think that's a good place to look for the intent of not only, since this our Act 31A is named after that act, it's good to look at that for some precedent. But anyway, what happened, a subpoena was requested by Deputy Hunt from Judge Paponio, and that subpoena, and there's, as far as I know, my years, there's never a hearing on that subpoena. It's just the prosecution would present the request for a subpoena, the judge would review it and issue it. So there was never a formal hearing, and you can see from the documents, there was not any mention of a hearing, and I can attest to you that they're normally, and I verified that there was no hearing regarding this request for a subpoena.
But you don't contest, I don't think, that a state entity,
Pardon me?
a state entity can obtain financial records if it's in connection with a criminal investigation, can't they?
Oh, I have no, absolutely, but I think it's clear from this act how they have to do it.
But was the negligent disclosure that's alleged here the state or the bank?
The state.
Who did the state disclose it to?
Well, no, it's in their attempt to get the records.
But the statute, the statute talks almost entirely about negligent disclosure, not negligent receipt.
Well, I think if you look at, I think the 31A, 2A, 5B indicates that any customers whose financial records or the information contained therein has been negligently disclosed by a state entity, it wouldn't have happened. The records would not have been disclosed without the subpoena being issued.
Don't have any problem with that. But for the state to be liable under this statute, would they not have to have negligently disclosed what they received to somebody else, rather than essentially receiving them? Isn't your cause of action, Mr. Bruce, you're contending that the officer, when he went and got the subpoena, negligently issued the subpoena, which resulted in his receipt of the records. Is that essentially what you're saying?
Yes, that's, I mean.
Okay, and I guess my point is, this act doesn't talk about negligently receiving documents or records, does it?
Directly, no, but I think how do you don't get the negligent disclosure, there wouldn't be any, but for the fact that the subpoena wasn't issued correctly.
Well, but the institution has an obligation to make sure they don't negligently disclose records, and they are essentially the protector of your client's records, and they had a right and possibly an obligation to prevent disclosure under that subpoena, did they not?
Yes, and we indicate that. That's why they were brought into this case also.
And that case is still pending below, right?
No, that case is settled.
Okay, so that part of it's over.
Yeah, that part of it is over.
But they were not dismissed as part of this proceeding?
Yeah.
Okay. Right.
Yeah, that case is completely, the BB&T case is completely over.
Okay.
What I think, if you look to what the statute's purpose is to assure that records are not obtained without the formality of being the subpoena being correctly obtained by the state. It's a two-party system. And I think it's clear the only way you can prevent it is make sure the subpoena is issued correctly in the first place. It's only a notice procedure, and it clearly states in the statute that the notice can be waived by the court. And the point in question here that we're asking the court to address is all they had to do is go in and say, we want these records, but we think the owner of the records does not need to have them because we're afraid they're going to run, or they're going to take some assets and dispose of them, whatever. It's not a complicated procedure, but it should, under the Act, be required of the state entity that's getting the subpoena, as it's well stated in the statute, to do this before they request it. They're compelled to do that before they request this statute. It says that. The statute's clear. And if you look at the federal statute, I mean, it requires a letter to go out, be mailed to the, under 12 U.S. Code 3407 judicial subpoenas. It's required a copy of the subpoena that must be mailed, or indicating it's going to take effect unless you object to it within 10 days. So that's not onerous, but that certainly gives the person the right to go in and protect their records from wrongful disclosure. And I think we need to establish that clearly in the state. That is the law. What else does the statute mean? And the statute under B, under 31A, 2A, 5B, is any customers whose financial records of the information contained therein has been negligently disclosed by a state entity or a financial institution. Well, you know, you can connect the dots. It wouldn't be disclosed. It is being disclosed by a state entity because they're requesting it. They're getting it. And the law is they can't get it unless it's disclosed to the person they're getting, unless there's a waiver. So they can't get the statute. They can't get the documents. They don't have a right to them. They can't request them from the bank.
Doesn't that statute, though, I mean, it's somewhat unclear in a couple areas, in my opinion, as to who is responsible for that compliance, because it doesn't say necessarily that the agency seeking it is the one that provides the notice. It's a little unclear, but even if it did, if they had to provide the notice, it said a financial institution may disclose or produce financial records if that takes place. So does that burden fall upon the person seeking the subpoena, or the entity seeking the subpoena, or does it fall upon the financial institution to ensure that compliance before those records are released? That's
a great question, but it's our point. It's a two-step process. You know, if a subpoena comes in from the state for financial records, it's not other records, it's not required anyplace else, but if it comes in to a bank, it must state that their account holder has got notice, or it must state to the bank, to protect the bank, it must state to the bank, notice has been waived specifically by the court.
And if that didn't occur, what should the bank do?
Not release the records.
Absolutely. I agree with you.
Not release the records. But because, look, this happens every day. What happened is we got either no one was aware of the statute because there's no case law on it, and it's not cumbersome to get a subpoena issued for financial records. The other subpoenas aren't bothered by it. It's just this one. And it calls for, in B, it says if a state entity or financial institution is proves that the state entity or financial institution negligently disclosed, well, did the state entity disclose it? Yeah. They requested it. and they got it. So it's been disclosed to them, and they're not allowed to do it unless they have the waiver from the court. And, you know, the appellee in this case argued that, well, we didn't know any different. The state requested it. But that's not what the law says. That's not what the law says. And we need you to come and tell us, or tell the courts, that you can't, as far as financial records go, the federal law is existence, and our law copies of that, and you got to have that hearing to make sure the person is protected.
I think we understand. We'll give you an opportunity to reply, but let's hear from the other side.
Okay.
Thank you, Justice. My name is Wendy Grieve, and I represent former Greenbrier County Sheriff's Deputy Corporal Hunt. He is now with the Putnam County Sheriff's Department. Just as a preliminary note, we do object to a recitation of some sort of impropriety in the procedural histories of the justices or judges in Greenbrier County's handling of subpoenas from law enforcement officers. That is completely objectionable. There are no facts in the record that would allude to that whatsoever. A critical point here that is consistently misrepresented by counsel is that the subpoena was issued by Corporal Hunt, that it was Corporal Hunt's request. The order from Judge Pomponio on its face notes that the motion was by the prosecuting attorney, which is completely proper. At the time that the order was entered, the plaintiff had already been criminally charged with the crime of felony abuse, financial abuse of elderly. The corresponding petition was filed by the prosecuting attorney to obtain additional financial records showing financial transactions from the Vanderpools where they had transferred property and money to Mr. Boswell, whose only relationship with them is that he had sold them a car and had no familial or contractual relationship with them. There is no law in the state of West Virginia that requires a sheriff's deputy to dictate to the court that notice is required in any form whatsoever in issuing the subpoena. None. There is no cause of action in West Virginia under this statute or any for the negligent serving of a subpoena by a law enforcement officer. The only acts, and everything has to be viewed, as I believe the justices have already noticed and pointed out, everything here has to be viewed in the context of the acts alleged against the defendant. Here, the acts are not the intentional, willful inducement by a state entity or employee to get the financial institution to disclose the documents. That's not alleged. What is alleged is that Corporal Hunt negligently induced the financial institution or its employees to disclose the documents. What is also alleged is that the defendant Hunt knew or should have known that 10 days notice was required for the customers before the financial institution could disclose, and that law enforcement officer also should have read everything that was being served on the financial institution, determined that there was a defect in the order from the judge and the subpoena, and not served it. That's preposterous. This statute does not provide for that at all. What this statute does provide is that there is no cause of action for the negligent serving of a subpoena. That's what's alleged here. Before we get to the penalty phase, which is Section 7, what we have to look at first is whether or not there was any duty imposed upon the law enforcement officer. Any. And if so, was a breach of that duty actionable? Because this specific statute provides it is the exclusive remedy for a violation. You can't say you've got a negligent violation of a part of it. You have to bring your action under 7A or B. So, plaintiff's counsel in this case argues that the statute was violated by Corporal Hunt because he did not give the notice required under Section 5. Nowhere in Section 5 does it say anything about law enforcement officers. As Justice Hutchinson noted, it provides a duty to the financial institution prior to disclosing the records. It does not provide a duty on the part of the individual officer who allegedly served the subpoena. I would note that Justice Hutchinson also asked about the status of BB&T. I learned yesterday that before plaintiff's counsel settled the remaining claims against BB&T, Judge Alsop actually issued an order addressing the application of Section 5 to BB&T. As this is a de novo review, I'm not sure that it's dispositive. However, I think it's important for the court to know that Judge Alsop ruled that Section 5 did apply and did require that notice be provided. However, Judge Alsop ruled that there could be no violation of Section 5 in the facts of this case because the subpoena was issued for good cause. And the for good cause finding by Judge Pomponio in his order meant that no notice was required. There are two portions of the statute that address scenarios where there is an order and then a subpoena. The first one, it's our position, applies here, and we don't go further, and that is Section 2A4. Under that provision, there is no notice requirement by anybody for records that are obtained pursuant to a court order connected to a civil or criminal proceeding in which the same entity is a party. There is no dispute that those are the facts of this case. We don't reach anything else here. There was no notice requirement. If the court did find that Section 5 applied, which again deals only with financial institutions, it is our position that under 5A2, no notice is required if service is waived for good cause by circuit court of competent jurisdiction. In this case, the writing of the subpoena was determined and dictated by Judge Pomponio. Judge Pomponio said, for good cause, the clerk of the court is directed to issue, and then he noted the following: what records were to be obtained, and at that point he could have included notice requirements. Judge Pomponio did not, and there is a finding of good cause. BB&T received notice of that finding of good cause because the order also required that in serving the subpoena ducis tecum that Judge Pomponio's order be attached to it. That's what was served. So here, BB&T and anybody who served the subpoena, if they read them, would have seen a judicial determination for good cause and a no notice requirement. It is our position that even if the court found that 5A applied to anybody, that it was not violated because there was no notice requirement. So here, not only were there no duties imposed on Corporal Hunt, there was no procedural violation of any provision of 31A. We shouldn't ever reach the remedies portion, the penalties portion, But if we did, what plaintiff's attorney originally started arguing in his complaint was 7A. In his complaint, he alleged that there was a knowing inducement for BB&T to disclose the records. That has been consistently disavowed, and it's been disavowed before this court. He now claims he wants to bring a negligent inducement claim. The statute doesn't provide for that. The statute only provides for the negligent disclosure of the records. There is no record in this case, or even an argument by plaintiff's counsel here today, that there was any disclosure by any state entity, however state entity may be defined by anybody. Again, the only allegations here are that Corporal Hunt allegedly obtained a subpoena. Not true, not actionable even if he did. And 2, negligently served a subpoena because he didn't read it, he didn't decide to disagree with the judge, didn't decide that it had additional legal requirements that weren't in there, and bring it back. Absolutely not actionable. The dismissal of this case with prejudice was absolutely proper, and we ask that this court uphold it. Thank you.
You don't challenge the petitioner's position in this case when they challenged Judge Alsop's finding that this statute did not apply to a Greenbrier County deputy. He made that finding. He said that this statute did not apply. Mr. Bruce has challenged that. You don't disagree. You don't.
I do think that it could apply to an intentional act of a deputy if it's under A. I don't know that it would apply under B because
well, didn't Judge Alsop say essentially that this entire statute did not apply to the deputy sheriff because he was not named? I mean, there's one part of the section, one part of the statute that talks about county governments, and then the other part of the statute leaves them out. So there's kind of a dichotomy there.
There's a lot of confusion there. I don't disagree that under the facts of this case, the individual actor for the Greenbrier County Sheriff's Department is not a proper party. What makes it more complicated is that the Greenbrier County Sheriff's Department isn't even a legal entity. So it can't be sued, and it can't sue. So and that's under Chapter 7-11, County Commission is the only entity that can sue and be sued. So plaintiff's counsel was arguing in front of Judge or actually it was in front of Judge Pomponio, and had represented, well, I'm not suing Corporal Hunt. I'm suing the Greenbrier County Sheriff's Department. Well, that's grounds alone for dismissal under any act because you can't sue them. He didn't bring a claim against the political subdivision, which is the only entity that can sue. And in that case, it would have been the Greenbrier County Commission, which Barry Bruce cannot sue because he actually represents them. So that's where we were on that argument.
All right. I understand your position.
Counsel, if I might follow up, I'm, again, looking at the definition, 31A2A1 explicitly defines state entity as any state or local government office, officer, department, division, bureau. I know what the petitioner's posture is, that the corporal falls under the definition of a state entity. Is it your position that the corporal would not be within the definition of a state entity?
Under the facts of this case, I would have to say no. I think that the finding in the order should have been, and I take full responsibility for this, should have been negligent disclosure by a state entity.
So for this particular case, you do not believe that the corporal falls within the definition of a state entity?
For this particular case, yes. The acts that get alleged against him.
Well, he was clearly acting within the scope of his duties and responsibilities. How So you're saying depending on the facts, sometimes a corporal issuing or I'm not issuing, serving a subpoena would be a state entity, but at other times they would not, depending on the facts?
The way state entity is defined in the definition section of Chapter 31A.
And I'm looking at it right here. Yeah.
By necessity, if you look at the penalty phase, that has to be read in conjunction with both 711 and 2912A. So when you're looking at, in this case, Deputy Hunt, Plaintiff's counsel has alleged that he's not actually suing Deputy Hunt. He is suing the Greenbrier County Commission. So he's saying he's suing the Greenbrier County Sheriff's Department. That's not a legal entity that you can sue. So defining it under a penalty phase, where this statute says you can bring action against a state entity, well, that can never be the Greenbrier County Sheriff's Department.
Maybe worthy of this court's consideration to clarify, as you've appropriately said, that under the definitions versus the penalty, there was somewhat disjointed.
I agree. And I think that there, of course we don't have legislative histories that can give insight into what the repartee may have been, but under A, the legislature clearly set out and defined that liability under the penalty phase A could be against individual employees or government officials. Now, they could have chosen to use the definition of state entity as it's defined in Section 1 of Chapter 31A, but it didn't. So then we look at Section B, and it doesn't identify financial institutions' employees. It doesn't identify employees or even local governments. It only says state entity. So while state entity is defined in one part of the statute, it makes absolutely no sense to insert that definition, I believe, under B. I don't think that's what's dispositive here, but if there could be clarification, I think that might help in the future. Now, I think there must have been some discussion somewhere, because under C of the penalty phase, the legislature went on to say, under no circumstances should any person be held liable for disclosing records if the subpoena appears to have been issued by, I think it was by a lawful court or a court order. So I think that there may have been some inkling that this could create problems. Thank you.
All right, thank you. Mr. Bruce?
I certainly need some time to rebut that.
Do you have a position on this, what appears on its face to be a quirk of the statute by not using state entity in
yes. I want to point, first of all, this case has been a car wreck with my client being rear-ended because we've had 4 judges. I just want to give you a little history. Bear with me for a moment. 4 judges.
If you could focus on replying to the arguments. I understand it has an interesting procedural background, but I think our primary concern is the applicability of the statute in this case.
Well, let me go directly to West Virginia Code 31A 2A2A. And this answers the question. No state entity may have access to or obtain from a financial institution financial records of any customer except as set forth in 31A 2A4 this article or under the following circumstances. So that goes to say that this act applies to a state person attempting to have access to those records. And if you look at paragraph 2 of that, 2, it says the financial records are disclosed in response to a judicial order, warrant, summons, or subpoena issued by a court of competent jurisdiction or a valid administrative order or subpoena of a state entity expressly ordering or requiring the disclosure of financial records, provided that any subpoena issued pursuant to the provision of this section shall comply with the provisions of section 31A2A5. So I think it's clear, and I think the court has been misled in that regard, that it is a violation of this act for a state entity, and then as 31A2A1F gives an expanded definition of state entity. The state entity means any state or local government, office, officer, department. What's that? Any state or local government, office, officer, department, division, bureau, board of commission, including the legislature and any other state or local government agency of West Virginia, its political subdivisions, and any agent thereof. That's the most expansive definition of state agency that I've seen. And it certainly applies in this case. Now, how does that fit in? Well, all you have to do is go to 2912A5. 2912A5 B3. It says an employee, going to B, it says an employee of a political subdivision is immune from liability unless one of the following applies. And 3 is liability is expressly imposed upon the employee by provision of this code. Well, it is. The employee, the deputy sheriff, is covered under this statute. It is expansive because the liability is expressly imposed upon him under a definition of what a state entity is. Now,
even if we take that as true, the liability is expressly imposed upon the employee by provision of the code. I've yet to really understand where liability is imposed upon this deputy unless that deputy takes those documents and improperly discloses them to someone else. And I guess that's where I'm still not sure what the statute is that you believe this deputy violated by issuing the subpoena and getting the documents in terms of the investigation.
Well, let me take you back. That's a fair question, but I take you back to A. 31A, 2A states, no state entity may have access. He's gaining access to those documents. Now, I want to clarify, there's no question that the deputy went to the prosecutor and said, I need these records. And that's who was responsible for getting the subpoena, and the subpoena gave it to him to have him served. He's named on that subpoena in it. Those documents are supposed to be delivered to him, not somebody else, not to the prosecutor, to him. He's to pick them up. So he's having access to those, and he's requesting access to those. It's covered. He's covered. Now, the penalty phase that Council C has nothing to do with the state employee. Going back to the penalties in 7, that covers only the bank. That's in case a bank person gets a subpoena and believes it's okay, that they cannot be criminally charged or sued. If it's on its face, it looks normal. It has nothing to do with the officer or the government aspect of this proceeding to get it. And so it's absolutely clear in my mind that The deputy in this case was covered under the statute, and this statute does not only cover the subpoena and the person giving the documents, but it covers the person who may have access or to obtain from a financial institution the records. It's their responsibility to get it done. So I hope that clarifies it. But I want to say something else.
How about make it your concluding remark?
Okay. I think it's very important. The statute's very important to protect the public. I see it all the time. What's wrong with making a prosecutor or a deputy who serves it having access, he's the one getting access, make sure and be educated that we're going to require it, as the federal law does, to give notice unless that court is given good cause. Every subpoena that's issued, I bet you throughout this by every judge, by most judges, is issued for good cause. Just for good cause, for good cause. When it comes to financial records, there needs to be good cause not to give the account holder. It needs to be documented that there's evidence taken that there is good cause. And the fact that Judge Alsop, which I have a big problem with, indicated that there was just cause when he had never looked at the file before he signed an order of this case. Never looked at the transcript, never had the file in his hand before he signed any order. This order particularly.
I think we've got it.
Thank you.
This case will be submitted.
Appreciate it. Have a good day.
The next case for argument, State of West Virginia versus J.C., docket number 170713.
This one's a train wreck.
May it please the Court, my name is Matthew Brumman with Public Defender Services, and I'm here today on behalf of the petitioner, J.C. This case presents this Court with a significant issue, but its resolution comes down to a very simple truism. Criminal commitment governs criminal cases, and civil commitment governs civil cases. My client has never been indicted for any crime, nor can he be, and the Circuit Court therefore erred by criminally committing him for 35 years. Now, that truism aside, the legislature has also made clear that civil commitment governs civil cases. In Chapter 49, the legislature has said that juvenile adjudication is not the same thing as a conviction. It's even said that it can't be used analogously, that none of the civil disabilities that would result from a criminal conviction apply to juveniles. Furthermore, in Chapter 27, dealing with commitment, there's a statute that specifically governs which portions of commitment are applicable to juveniles under a court's juvenile jurisdiction.
In this case, there was a motion pending to transfer the juvenile to adult status prior to the competency hearing.
That's correct, Your Honor.
Okay, my question is, do you contend that after the juvenile was found incompetent, could the state have gone ahead and proceeded on its motion to transfer and then treated him civilly as an adult, or were they precluded?
I think they were precluded, Your Honor. Excuse me. Transfer hearings are a critical stage of the proceedings. The United States Supreme Court has described it as a bright line of tremendous consequence that we don't do without a meaningful hearing. And as a critical phase of the proceedings, the juvenile respondent has an absolute right to be present and participate meaningfully in his defense. If he's incompetent to stand trial, he's incompetent to be transferred.
So under your contention, there would be no ability of the state to have any type of jurisdiction after he was 21, even in where seriously incompetent person allegedly did a very serious crime?
Actually, Your Honor, I don't think that in this particular case, I don't think 21 was even a cutoff. I think that under the court's juvenile jurisdiction, it had to dismiss the juvenile case at that point. However, that does not mean that the state did not have options. First of all, prior to all of this ending, there is a possibility for improvement periods and things like that under the juvenile code. But even beyond that, as I've mentioned, civil commitment still governs civil cases. And if the state felt that it was necessary to protect the public, they could have sought civil commitment at that point. And they still can do that now, Your Honor.
Did I hear you say that the juvenile case has been dismissed?
No, Your Honor, I apologize. I said that should have been the resolution of this case.
Okay, but so right now he is still currently under juvenile jurisdiction because there's a pending delinquency. Is that right?
Well, I mean, that's an interesting question. He's been committed under the criminal commitment statute. Without an adult transfer hearing, the style of the case magically changed to reflect a more criminal proceeding rather than a juvenile case. He's been treated as though he had been transferred to adult status without ever having an opportunity to be heard on that.
And once he turned 18, they shipped him over to Sharp, right?
Yes, they had to ship him from Sharp from a facility in Tennessee because West Virginia doesn't even have facilities for criminally committed juveniles. There's nowhere in this...
And Sharp magically massaged him and he is now competent, right?
That's what they tell me. I think that we have a pretty good case on the merits on that if it should come to it, but...
well, what's got to happen with that now is it's got to go back to the judge under the delinquency case for the judge to make a determination whether he agrees to competency, right?
I don't think so, Your Honor. And it's because he was found incompetent, non-restorable at the time that this case was disposed of below. If he had been found competent, restorable, I think it would have been appropriate for the court to maintain jurisdiction for a period. That would be good cause to continue the adjudicatory process and to see if competency could be restored. But the moment he was found incompetent, non-restorable by the circuit court, under Chapter 49, under the court's juvenile jurisdiction, it should have dismissed the case outright. There should not have been an opportunity to try and restore competency. Instead, the state should have focused on treatment, like he received in Tennessee, but did not receive in Sharp at the expense of this competency restoration program that they subjected him to. Furthermore, in addition to the legislature's enactments in Chapter 49 and Chapter 27, this reasoning is entirely consistent with how this court has already applied these statutes. In State v. J.E., this court was presented with the issue of whether someone who was adjudicated a delinquent for an act that would have been a sexual offense had to register as a sex offender for life. And this court followed this exact same analysis, that under Chapter 49, adjudication is not the same thing as a conviction, that it's not even analogous to conviction, that juvenile respondents are not defendants and cannot be treated as criminals. And as a result, this court ruled that if if the state does not conduct a transfer hearing properly and does not transfer a juvenile to adult jurisdiction, that they cannot be required to register as a sex offender. The legislature is free to change that. These are all matters of very important policy to our political branches, and the legislature is certainly free to change this at any time. But as it stands right now, the legislature has said criminal commitment governs criminal cases, civil commitment governs civil cases, and juvenile jurisdiction is civil. And there's something else I'd like to hit on with this, because we keep using the word juvenile. I'm drawing a distinction between juvenile, meaning someone under the age of 18, and juvenile in terms of the court's jurisdiction. Justice Workman, you mentioned at the very beginning, what happens with the order of adult transfer in cases like this. If he had been successfully transferred to adult status and then something happened whether he decompensated, had a schizophrenic break, suffered some sort of injury that caused him to at that point lose competency, he would be under the court's criminal jurisdiction at that point, and they could proceed against him as the circuit court below did. But here, my client was incompetent from the beginning. He was incompetent at the time of the alleged acts. He was incompetent prior to the transfer hearing. At that point, criminal commitment simply isn't appropriate. The juvenile was still under the court's juvenile jurisdiction, its civil jurisdiction, and a criminal commitment for 35 years for a 17-year-old was simply inappropriate. Now, if there are no other questions, Your Honors, I'll conclude briefly by just saying that, this comes down to the simple truism. When the legislature, this court's case law, and common sense all speak with one voice, this court's task is very easy. Criminal commitment governs criminal cases, and civil commitment governs civil cases. Thank you.
May it please the Court. Lindsay C., State Solicitor General on behalf of the state. Counsel for J.C. has argued that the Circuit Court has no continuing jurisdiction over the juvenile in this case, and that there is no ability to transfer this case even, and that this result applies no matter how serious the offenses that are alleged in this case or in future cases. This Court does not need to reach that result, and in fact doing so would be contrary to the position that this Court took 5 years ago in the case of Smith v. Sims. Sims involved a case where there was a 12-year-old and there was no question of transfer to adult criminal jurisdiction, and this court applied the Chapter 27 incompetency proceedings in that case. This court squarely held that Chapter 27 applied where the two requirements from that provision are satisfied. First, there's an incompetent individual, and second, the offense charged dealt with violence to an individual. Those were the two critical requirements, and this court found that Chapter 27 applied, even in the case of a 12-year-old.
Wait, was that 12-year-old transferred to adult status?
No, Your Honor. Okay. No, Your Honor, there was no question of transfer in that case, so it was even more clear than it is here. This was a juvenile. There was no question that the juvenile could be transferred to adult criminal jurisdiction, and even so, this court found no issue in applying Chapter 27. In fact, this court found that when the Circuit Court in that case had dismissed the juvenile petition, the error was so clear that this court found that a writ was appropriate, which this court only rarely does when the prosecution asks for a writ in a criminal case. Here, the counsel for J.C. is asking for the exact opposite result, and in a posture that has an even higher burden for the defense, because it's undisputed here that this question of whether Chapter 27 applies was not raised or objected to or argued below. So defense counsel recognizes that this is a case where the plain error review analysis applies. This is simply not a plain error case. There's no error in this case, no reason for this court to revisit its decision in Sims, and even if this court were inclined to revisit Sims, at most that would mean that this is an ambiguous issue of law, which means that even if there were error, it certainly would not have been plain to rise to that high standard of plain error review. Defense talks a lot about the case of J.E., but that decision simply does not alter the result the court has already reached in Sims. Nothing in J.E. was about Chapter 27. It doesn't address Sims at all. And in fact, this court has already, in the case of George K., which is cited in the state's brief, this court's already addressed the intersection between the sexual offender registration statute that was an issue at J.E. and Chapter 27. And there, this court found that there are very different statutes that are geared towards different purposes. One deals with the ongoing consequences of a criminal conviction in the sexual offender status. The other deals with the procedures in the middle of an adjudicatory procedure where the individual is not competent and where it's necessary to take steps to protect that individual and the public. So this court has already rejected the comparison defense counsel is urging now to say that the analysis in the sexual offender case should be applied to Chapter 27.
But now let me ask you this. You referred to that Sims case. Wasn't that the case? This issue presented today wasn't directly before the court, was it?
No.
Wasn't that what constitutes an act of violence?
Yes, Your Honor. That is the question that was at issue there. It was not squarely presented whether Chapter 27...
You're just saying these same facts existed, but if it wasn't raised as an error and the court didn't address it, do you think that is authority to rely upon here since it has been brought directly to us?
I do, Your Honor, in this case, and that's because it was a necessary finding. A threshold question that was, unaddressed specifically in that case was whether Chapter 27 applied at all. And because those facts were even more plain than they are here, it dealt with a 12-year-old and no question of transfer, there was simply no need to raise that question because the result was so clear there. If the court found no question and no concern with applying Chapter 27, even under those more extreme facts, there's no reason for the court to do so now.
Justice Cleckley always said that judges shouldn't be like, pigs that snort around in the mud for truffles, and if it's not raised as an error, it should never be addressed.
Well, of course, Your Honor. We would suggest that this is not a truffle that the court would be searching for when there's a case of a 12-year-old who's before the court under a statute that's arguably applies only to adults' jurisdiction. That would be an obvious issue there.
You're right about that. It's not minor.
But of course, Your Honor, we also think that there's no reason for the court to overrule Sims, even if the court does not rely on Sims for persuasive authority in this case. Again, in J.E., which is the only case the defense counsel has said to call this line of cases into question, there was simply no discussion about this intersection of the competency statute. The issue there dealt with a separate presumption about when the effects of criminal convictions can attach to a juvenile adjudication. And we have a strong presumption that when a juvenile is adjudicated of an offense, that the consequences are not going to follow that individual into adulthood. But that doesn't apply when you have a non-punitive statute. And it's undisputed that competency proceedings and commitment in this case is non-punitive. The goal is not to punish the individual, but to protect the individual and to protect society. So the same presumption doesn't apply there. Looking to the text of Chapter 27 itself, it is clear in 27(6)(a)(3) that this chapter applies to those who are charged or indicted with an offense. And in juvenile proceedings, when a petition is brought, those are charges. Charges is the language that's used in Chapter 49 for juvenile offenses. So Chapter 27, which deals with incompetency, plainly extends to both juvenile and adult criminal proceedings. It would also be contrary to the purposes of the statute to say that Chapter 27 doesn't apply in the case of an incompetent juvenile. What defense counsel is asking for is to create a carve-out where the circuit court simply has no jurisdiction over the juvenile. Significantly, defense counsel said that this isn't even a case where he was arguing that the jurisdiction should end at age 21, but that the court has no jurisdiction at all. The legislature simply did not intend to create this vacuum where if an individual is found incompetent in the midst of proceedings, we have a procedure that protects the individual and the public if the individual is an adult, but we have no options for the court to protect the individual and the adult if that person happens to be a juvenile. There's no indication that that's what the legislature would have intended. No options for treatment for that individual and no option for protection of the public when the act at issue is as serious as a charge of first-degree sexual assault is in this case. Additionally, there's no reason to say that the timing of a transfer hearing should be dispositive here. If the facts of this were different, if the transfer hearing had occurred before the competency determination, there would be no question that the court would have had jurisdiction under Chapter 27 to have authority up until the 35-year period for first-degree sexual assault. Such a significant issue that goes to the protection of a juvenile and goes to the protection of the public should not turn on the fortuity of when a competency hearing occurs.
You know, both of you are doing outstanding arguing jobs, but I guess I'm simple-minded. I keep coming back to the question of if the juvenile hasn't been transferred to adult status, how can you treat him under adult law, even relating to civil commitment?
Mm-hmm. Well, Your Honor, the first answer is that Chapter 27 is not something that's